Hello, everybody. I just wanted to welcome Erin Choquette to today's extended leadership meeting, and she is going to speak to us regarding and was a very important part of the Connecticut Paid Leave Act, and she is going to be giving us a great overview of the difference between the Connecticut Paid Leave versus the Connecticut Paid or the Connecticut Family Leave Act. So I will turn it over. It's a pretty full webinar, so I'm going to turn it over to Erin and let her give you a little bit of her bio, as I shared with all of you earlier today, and go from there.
Great, thank you so much for having me. Just a couple of housekeeping details. As we noted, we are recording this. If you have questions, please use the Q&A function in Zoom to put your questions in. That gives us the ability to keep track of them and actually access them even after the meeting's over, so that we can make sure that we respond to them, even if I don't get a chance to answer all of them during the time we have together this afternoon. We will share the recording and the slide deck, so you'll have that as a reference as well. So I'm going to go ahead and share my screen. And get to the slideshow. Okay. Can everyone see my screen? Great. So we'll jump in. So as mentioned, I'm Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority. Prior to joining the authority, I worked for the Department of Administrative Services. And before that, I was in private practice. My career has really been focused on employment law and insurance. And I've really spent a lot of time dealing with FMLA, training HR on how to understand and administer FMLA, and actually co-wrote a manual, which we are in the process of revising to make applicable for private sector. So that's something that's coming in the next month or so. I'm a proud graduate of Holy Cross, Girls Leaders, and Columbia Law School, and I'm really happy to be with you today to talk about all the fun that is Connecticut Paid Leave, and to talk about the changes that you'll be expecting with Connecticut FMLA come January. So we'll talk a little bit about the Connecticut Paid Leave program, and then really focus more on understanding the differences between FMLA and paid leave, and how we'll be implementing Connecticut Paid Leave, and how you as an employer will be implementing FMLA. As I said, if you have questions, please put them into the Q&A. Try and address things as I go, and then we have time at the end to really focus on those. And if we run out of time, we can always follow up after the fact. So the Paid Leave Authority, we're a quasi-public agency which was created to stand up and administer this paid leave program with the goal of providing income protection to employees who need to be out of work for covered reasons, usually caring for themselves or a family member. So our mission is to make sure that those paid family leave benefits are accessible to employees, but it's also to make sure that employers, administrators, and healthcare providers understand their roles in helping their employees and their roles with connection to paid leave. It's really hard to talk about paid leave without also talking about FMLA, so we've kind of taken that on as well. Statutorily, our responsibilities include doing outreach and engagement, educating people about the benefits and what's going on. We have to stand up this brand new agency, so we're developing all the policies and procedures needed to run the program. By statute, the contribution rate can be no more than 0.5%, but in the future, if the trust fund gets healthy enough, we may be able to reduce that. So that's under our responsibility, and we've been receiving contributions now since January. There is an opportunity for employers to comply with their obligations under the Paid Leave Act by offering a private plan to their employees. So we run that program as well. I really won't talk too much about that right now, because that's really for people who don't want to be part of the Connecticut Paid Leave program and want to do it themselves. And then starting actually in December, we will begin administering claims for paid leave benefits with our third-party administrator who we contracted with. We have a contract with AFLAC, so they'll be handling the nuts and bolts of the claims processing for us and with us. Just some key dates. We've been running nonstop since our board first convened. We started having employers register with us on our portal. Our portal actually went live a year ago. We had the employer registration opened last November. Contributions began in January. We started reviewing applications for private plans in February, and we just haven't stopped since. Starting in December, we will begin accepting claims for benefits. We won't pay any benefits until January, but if we know employees are going to be out sometime after January 1st, we want to get those claims in early so we can start reviewing them and avoid some of the backlogs that other programs have seen. So let's jump right into it. Who is covered under the Connecticut Paid Leave Program? Well, almost everybody. The statute says that if you are an employer who has one or more employees working in Connecticut, you're in the program. This includes not-for-profits. This includes private sector employers with unionized workforces. It also includes sole proprietors or self-employed individuals who choose to opt in. So if you have independent contractors working for Seabury, you don't have to worry about them. They have to enroll for themselves. You don't have to do anything for them. But if they choose to opt in, they can enroll with us. The statute does exclude certain entities, including the federal government, the state of Connecticut, except as to our covered public employees, which I'll define in a second. Municipalities and local or regional boards of education are also excluded unless they have covered public employees, and non-public elementary and secondary schools are excluded. This really is the same categories of employers who are not covered under Connecticut FMLA. There are other laws that have provisions which say that therefore their employees are not covered by us, such as railroad workers, individuals who work for governments of other states, employees of sovereign nations like Waukegan or Mashantucket. There are some interstate commerce rules and some specific issues associated with spouses of active duty military members, where they basically pay taxes only in their home state, so they're not covered by us. I told you I would define a covered public employee, and that is a four-part definition. So non-unionized employees of the state of Connecticut are participating. So managers, appointed officials, and elected officials all participate. We've all been contributing and will be able to apply for benefits. Unionized employees of the state of Connecticut can collectively bargain to be included. And then employees of municipalities or local or regional boards of education will only be included if their unionized employees collectively bargain to be included. If that happens, then everybody, the non-union folks too, all come in as well. So as I said, we've been getting contributions since the beginning of the year. Your employee contributions are based on their FICA wages, and the contribution is 0.5% up to the Social Security contribution limit. I know you've been doing this for a while, but basically the employer remits the employer deducts the contributions from the employee's wages, and then on a quarterly basis remits those contributions to us with some basic wage information. We receive those contributions and they go straight into the Paid Leave Trust, which is actually administered by the Office of the State Treasurer. And then that trust is our sole source of income. That's what we use to fund the benefits and administer the program. All right, let's get into the stuff you really want to hear about. FMLA and Connecticut Paid Leave. So when you hear about FMLA, the first thing to know is that there are two different Family Medical Leave Acts. There's the federal FMLA and there's also a Connecticut FMLA. Both of these laws allow eligible employees to take protected work. Sorry, I should never do this, but I just read the chat, so I'm going to answer the question. The question is, if the employee works in Connecticut but lives in another state, does that mean they're not covered? No, that is not correct. If they work in Connecticut, they're covered, regardless of where they live, unless they are engaged in interstate commerce, so like a long-distance trucker, or if they're a military spouse. Okay, sorry. Let me go back. And please use the Q&A and not the chat. So FMLA, federal FMLA and Connecticut FMLA both allow eligible workers to take job-protected time away from work. Under both of these statutes, the language says this leave is unpaid, but the employer may adopt policies that would provide income replacement during the leave. So some employers just continue wages. They just provide for it. More often than not, however, you'll see employers who have paid leave policies that usually involve PTO or sick leave and say, you're required to use your sick leave if you're out on your own serious health condition, or you may use vacation leave if you're out. So that is still the law. Connecticut FMLA is going to change significantly. It's been on the books since the 90s, but as we'll discuss in a moment, it's undergoing a radical reconstruction as of January 1st. On the other hand, well, let's talk about that. Right now, Connecticut FMLA only applies to employers with 75 or more employees, and those employees have to work for at least 12 months and have worked for at least 1,000 hours in the 12 months before they start leave to be eligible for job protection. And the leave entitlement is 16 weeks of leave in a 24-month period. But there's one particular type of leave called military caregiver where you can get 26 weeks of leave. In January, this law is going to change, and it's going to start applying to employers with one or more employees. And then more significantly, job-protected leave will now be available to all employees as long as they've worked for you for 3 months, and there will no longer be an hours worked requirement. This is a significant change. The other significant change is the entitlement. It's going to switch to 12 weeks in a 12-month period. You still have that 26 weeks of leave for military caregiver, but now an individual who suffers from an incapacitation during pregnancy could get up to 2 additional weeks of job-protected leave. Under both the old FMLA, Connecticut FMLA, and the new Connecticut FMLA, employers can adopt policies requiring or permitting their employees to use accrued paid time or other paid time off during their FMLA leave. However, as of January, the employer has to let an employee hold on to 2 weeks of their accrued time. Basically, you can't require an employee to exhaust all their accruals if they have FMLA. When this was being debated in the legislature, there was a lot of testimony about people who, had planned the trip of a lifetime, the cruise or the trip to Disney World, and then broke their leg, and then had to use up all their accruals. Then they came back to work, and now they couldn't go on their vacation that they'd been planning for years and years. So the legislators carved out this 2-week piece. All right, that's FMLA, and we'll talk more about that in a minute. But let me define Connecticut paid leave for you. We talk about it as CTPL, or Connecticut paid leave. There's the statute, the Connecticut Paid Leave Act, which can be found at 31-49E of the Connecticut General Statutes. There's the program, which is what we created, which provides for these benefits and sets up the contributions. And then there's us, the authority, the paid leave authority. Sometimes we use CTPL for all 3 of those things. Basically, this is the act that creates a source of income replacement benefits for people who are out of work for these job protected or these qualifying reasons. It does not provide job protection. That's the big difference. FMLA provides job protection, CTPL provides money. People also refer to it as PFML, or paid family medical leave. We've gotten out of the habit of doing that because if people see PFML, they think FMLA. And so we try and have as few overlaps as possible. CTPL reads differently than FMLA, and so it's helpful in making sure people understand the difference. Under both FMLA, Connecticut FMLA that is, and Connecticut Paid Leave Act, there are qualifying reasons, which include medical leave. So that's when you have to receive treatment or recover from your own serious health condition. The definition of serious health condition includes pregnancy. It also includes serving as an organ or bone marrow donor. There's also caregiver leave, so you're caring for a family member who has a serious health condition. There's bonding leave, which is basically to bond with a newborn or a newly adopted child or a child who's been placed with you for foster care. Or for foster and adoption, You can use bonding leave to attend to some of those mandatory pre-placement activities, like going to court, going to pick up the child. So before you get the child, it counts. I've mentioned military caregiver leave, and that's leave for an employee to take time away from work to care for their family member who was injured on active duty in the military. There's also something called qualifying exigency leave. So your employee has a parent, spouse, or child who has been called to overseas active duty and needs to take time away from work to address issues that are related to that call, like having to update their will or their financial procedures, or attending a sending off ceremony, or setting up some emergency childcare. Then there's also a Connecticut statute called the Family Violence Leave Act that allows employees to take time away from work to go to court, to relocate, or to receive treatment or counseling if they have a victim of family violence. That law has been on the books since about 2012, but now employees can receive income replacement if they take unpaid time off for these reasons. The statute says the unpaid time off can be limited to 12 days in a calendar year, and so the benefit is also limited to 12 days. The caregiver leave that I described for you, when you have to take time off to care for your family member who's sick, or to care for a military member who was injured in active duty, under Connecticut law, that's a lot broader than it's been under the past. In the past, you could only take leave for a parent, spouse, or son or daughter. And for regular FMLA, the son or daughter had to be under 18. For military caregivers, any age. Now, under both the new Connecticut FMLA, you can receive leave, and under Connecticut Paid Leave Act, you can receive benefits if you're taking time off to care for your parent or spouse, your son or daughter of any age, or to care for your sibling, grandparent, or grandchild. In addition, if an employee comes to you and says, I have a relationship with this person who I don't have a blood relationship or a legal relationship with, but my close association with them is such that they are equivalent to my parent, my spouse, my sibling, that also counts as a covered family relationship. The statute says that it's a person with whom you have a significant personal bond, like one of those relationships, regardless of the biological or legal relationship. We know that this is a new concept for Connecticut. It's actually something that the federal government has been doing for years in connection with federal contractor sick leave, for federal employees, bereavement leave, and similar situations. And other states and municipalities have used this. So we're following their lead. And we recognize it's really fact specific. So the employee has to provide to you documentation to demonstrate the relationship. It doesn't have to be, an inch thick file of, Christmas cards and pictures going back to when they were children. But they do have to be able to explain the nature of the relationship and show that, yes, this really is the equivalent of a family member. So, for example, in my family, my grandmother died when I was very young, but my great aunt really took the role of the grandmother. She came to every event. She came to all the school events. We took care of her. We did her shopping for her. We took her to the doctor. She was the equivalent of my grandmother. And so if she were still alive, I could say, I need leave and benefits when I have to take care of my great aunt. Also in Connecticut, we don't have common law marriage. So if you are in a significant other relationship, think Goldie Hawn and Kurt Russell, you could not take FMLA for them. But under our new law, that unmarried but significant relationship where it's familial or spouse-like would now be considered a covered relationship for both Connecticut FMLA and for the Paid Leave Act. So just a quick summary, because you do have more than 50 employees, you're also subject to federal FMLA. So federal FMLA does not change. Federal FMLA, you have to be employed for 12 months and work 1,250 hours in the 12 months immediately preceding the leave. That's the same as it's always been. It's not changing, at least not yet. As of January, Connecticut FMLA job protected leave will be available to employees who work for you for at least 3 months. There's no hours worked requirements. So your part-time workers who maybe never were eligible before will now be eligible. And then for paid leave benefits, you have to earn at least $2,325 in your highest earning quarter when we look at the first 4 of the 5 most recently completed quarters. We will be getting that data from the Department of Labor, supplemented by pay stubs and W-2s if necessary. But that's something we will be determining. And then the employee has to show that they're either currently employed in Connecticut or that they're currently unemployed, but they had been working for an employer in Connecticut at some point in the 12 weeks before they apply to us. Or they have to show that they are a sole prop or self-employed individual who lives in Connecticut who enrolled in the plan. That's to be eligible, and if you're eligible, you get these entitlements. For federal FMLA, it's 12 weeks in a 12-month period for all those leave reasons I discussed, except that federal FMLA does allow for 26 weeks of leave for military caregiver, and it doesn't have a family violence leave component. Connecticut FMLA, 12 weeks in a 12-month period, but as I mentioned, you've got those 26 weeks for military caregiver, you've got 12 days for the Family Violence Leave Act, and you've got those 2 extra weeks if you're incapacitation during pregnancy. For benefits under the Connecticut Paid Leave Act, your entitlement is up to 12 weeks in a 12-month period for all those leave reasons, including military caregiver. We don't have the capacity or obligation to provide benefits for up to 26 weeks, so it's just 12. But as I noted, up to 12 days could be used for family violence leave, and employee could get up to 2 additional weeks of income replacement if they have incapacitation during pregnancy. Okay, a lot of information. Let me just quickly look at the Q&A. So the question is, if they're out on National Guards and need to be out from mandatory drill or training, would they apply to us? That's a great question, and the answer is no. So for qualifying exigency leave and military caregiver leave, the leave is for the family member of the person in the military. It is not for the person in the military. And then also, for qualifying exigency leave, the call to active duty has to be overseas active duty. So if you have an employee who says, my spouse has to be away for a week in National Guard training, can I get time off and benefits? The answer is no, because it's not overseas active duty. Thank you for that question. And then another question came in. Can you get benefits from CTPL and FMLA simultaneously? Yes, and we'll talk about that. But remember, FMLA is job protection, CTPL is money. So you could be out on FMLA, and so you've got job protection there, but you have no money because you don't have enough accruals or your employer doesn't provide paid leave. You would come to us for income replacement during your leave. There's also a situation where an employee may not be eligible for job protection. Maybe they haven't worked for the 3 months, but they are eligible for income replacement. So it could be the situation where they end up having to leave their job because of the qualifying reason, but they could still get income replacement for a period of time from us. All right, let's talk about implementing Connecticut Paid Leave Act. 2 parts of the Connecticut Paid Leave Act. First is contributions. So the employee is responsible for contributing the 0.5% of their wages. This is entirely employee funded. The employer does not match. So the money comes from the worker, but the employer has to get us the money. So they have to register with us, they have to handle the deduction and remit it to us. And then the authority receives and reconciles those contributions, handle any over or under payments. We will impose penalties for non-compliance. And Department of Labor has authority under its general wage and hour laws to determine when employers can take deductions from employee paychecks. And this year, they've used that authority to allow employers to take catch-up deductions. They didn't get the contributions squared away in the first month of January. Employers basically got approval from DOL to say, okay, you can take extra money out to kind of catch up. That's going to be ending at the end of September. So So that's sort of general permission to just do extra contributions. But that's really it for contributions. The other half of it is the claims, right? So if an employee needs benefits from the paid leave authority, they need to apply to us. They'll have to create an account so that it can be done online. They can also call or submit it in writing, but we are encouraging people to do as much as they can online because that's where all the documentation will go. It's easier for everyone. They can access it 24 hours a day. They'll be required to provide us with supporting documentation to justify their need for leave. And they'll have to give us some information about when they're going to be out and if they're receiving any other sources of income. They also are required by law to notify their employer that they're applying to us for benefits. If they don't, we will, but we want them to tell you first. The employer's responsibilities in connection with paid leave claims are to complete an employment verification form, which gives us information about the fact that they're working, what their hours, their regular hours are. If it's a non-standard work week or a fluctuating work week, we're going to just ask for the last 12 week. Okay, do they work 30 hours a week, 45 hours a week, whatever. And to tell us if you're going to give them paid time off. We may need to follow up with you as the employer to validate the absences, particularly for intermittent leaves and other sources of income, for example, workers' comp. As the employer, you do need to let your employees know what your paid time off policies are. And if you offer short-term disability, you need to make sure your employees know that. And as always, you have to refrain from discrimination or retaliation. The paid leave authority with AFLAC, which is our third-party administrator, will determine the employee's eligibility, will review their documentation so we can approve or deny the claims. We will be calculating and paying the benefits, and we'll be monitoring those ongoing claims. We have a process for assessing requests for reconsideration. If we deny a claim, we will be paying attention for fraud, investigating and taking appropriate action, and we have authority to impose penalties. The Department of Labor is responsible for hearing appeals relating to denials of paid leave claims and to penalties. How does this work? Whoops, I went too far ahead. The worker submits the claim to us. They can create an account through our portal, and then click on a button to submit a claim, and that'll send them to AFLAC, or they can call AFLAC directly. Neither of those is live yet. We don't want to start accepting claims until December. So they're not live, but that's what's going to happen. The employee submits what we call an application checklist and supporting documentation. Documentation needed depends on the reason for the claim. And then they have to tell us, how long are they going to be out? Is it going to be out on the block leave? So one extended period of time. Is it intermittent leave where they're at work, but then they take small bits of time off? And they have to tell us if they have other jobs or other sources of income. We, through AFLAC, will be determining the eligibility, utilizing DOL data and other documentation as necessary. We'll validate that they work for a covered employer or that they're registered. And if they're not eligible, we'll notify them immediately. If they are eligible, then we let the employee know what additional documentation is necessary. We'll review that documentation, make sure that it's complete, and approve or deny. If we deny, there's obviously that opportunity for reconsideration. If it's approved, we calculate the benefits, again, using DOL data as well as information we receive from that employment verification form to calculate the base weekly earnings, which is set by statute. We do have to take into consideration if there's any employer-provided benefits, because the statute says that an employee could receive benefits from the authority as well as from their employer as long as the total amount does not exceed 100% of their regular wages. Then we'll issue the benefits either through an electronic transfer or through a stored value card, so a debit card. We are setting up a cadence where the benefits will be issued each Tuesday. We're saying it's 2 weeks in arrears. Personally, I feel like this is 1 week in arrears, but we want to be clear. So for the week of January 2nd, like that first work week, that week goes from January 2nd to January 8th. We will be issuing the benefits on January 18th. That gives us time to make sure that we have received information about any employer-provided benefits and can calculate the offsets. The employee is responsible for notifying us if there's any changes in their application, if they extend the amount of time that they need out, if they've got income that they weren't expecting. If it's intermittent leave, we do need them to keep us informed of how often they're going out on leave and making sure we know, because we're only replacing their income for time that they're not working. So we need to know when they're not working. When we calculate the benefits, it's going to be based on the statute. So the statute says if an employee is working less than or equal to 40 times the Connecticut minimum wage, then their benefit will be 95% of those earnings. So right now, Connecticut minimum wage is $13 an hour. So an employee who receives less than $520 a week would get 95% of their base weekly earnings, minus any offsets from employer-provided benefits. If they earn more than 40 times the Connecticut minimum wage, they'll get that 95% plus 60% of the difference between how much they earn and the Connecticut minimum wage times 40. However, in all circumstances, the benefit is capped at 60 times the Connecticut minimum wage. So if you earn more than $780 a week, your benefit would be capped at $780. Just by way of example, worker A earns the $13 an hour, so the benefits are really easy. It's 95%. We get $494. Worker B earns more than that. So we do the 95% of 40 times 13 plus 60% of the difference between how much they earn and the 40 times Connecticut minimum wage. And then we add the two together. And so you see in this scenario, the second worker receives $506 in benefits. As I mentioned, an employee could receive benefits from the authority as well as from the employer, as long as the total amount does not exceed 100% of their regular wages. So you take that fact, and then you take the fact that under Connecticut FMLA, the employer can require the employee to use paid time off, with that exception of keeping the 2 weeks in abeyance. What do we do? Well, first thing, if you offer a short-term disability policy from an outside insurer, talk to the insurer about the terms of the policy. Most of those private insurance policies that are offered through employers say that the short-term disability policy is the payer of last resort. So the employee has to use up all their employer-provided benefits and any benefits from the paid leave authority before they can even tap in. But check your policy. If you don't have an outside policy or you're thinking about changing it, these are some things to keep in mind. If an employee does not receive any employer-provided PTO, then they're going to start getting their benefits as of the first day they leave, right? And so that's easy. If the employee receives some employer-provided PTO that is equal to their regular pay for the full amount of time that the employee is out on leave, they don't need to come to us because they're getting fully compensated. So they're not going to receive any CTPL benefits for that leave. They're not tapping into their 12 weeks in a 12-month period entitlement. It's just a non-issue. On the other hand, which is where most of us are going to end up, if you have a worker who receives some employer-provided PTO that is equal to their regular pay for some small period of time when the employee is out on leave, then they can start getting CTPL benefits once they stop receiving that employer-provided PTO. So say you have a policy where the employees have to use their sick leave for their own serious health condition. And you've got an employee who works 5 days a week and they happen to have 5 days of sick leave. They would go out on leave on day 1 and use their 5 days of sick leave for the first 5 scheduled days of work. On day 6 of their leave, they'll start getting benefits from paid leave authority. If, on the other hand, you have a worker who receives employer-provided PTO that is less than their regular pay, say they only get 50% of their day's wages from the employer PTO, they'll get their employer PTO and their paid leave benefits both starting on the first day of leave. Make sense? In practice, I think this will be a lot easier, particularly because we'll be asking you for that information up front in that employment verification form. Sorry for keep pulling that. Okay. We're telling employees, look, you have to tell your employer that you're going to be taking leave or that you want to take leave, and you have to tell your employer that you want to apply for benefits under CTPL. So when you're having that conversation with them, find out, what are our policies? Do I have to use my PTO? Do I only have to use it if it's my own serious health condition, but I don't have to use it for caregiver? Whatever the rules are. Also ask if there's a short-term disability policy. I know that you tell your employees this, and you probably tell them frequently, but in my experience, people never pay attention until it actually becomes a situation where they actually need to use it. So you're going to have to tell them again. So we're telling employees, ask these questions. And then they'll be able to figure out how the CTPL intersects. All right, let me just look at the Q&A real quick. Well, I already answered that one. Cool. So let's talk about FMLA instead. FMLA is job protected leave. So, worker, I need job protected leave. I need to tell my employer, and I need to tell them in a timely fashion, 30 days in advance for a foreseeable leave, or as soon as practicable if the need for leave is not foreseeable. If you have a form or an application that you want your employees to fill out, and I hope you do, because it's the way to keep things organized, they have to complete that application. And they have to provide supporting documentation, a medical certificate for their own serious health condition, a family member certificate for caregiver, proof of the adoption, if it's bonding, the same kinds of things that we'll be asking for. And they still have to comply with your attendance and call-in policies. So it's important to make sure your employees know that. As an employer, you need to have a leave policy, right? Like you need to know if you're going to make your employees call in, if you're going to make them use PTO, you want to have a policy and make sure it's just disseminated to your employees. There are laws about posting your CT-FML and federal FMLA posters. Presumably you're already doing that. You'll have to process the leave requests and monitor your employees' leave usage. So FMLA is handled entirely by HR. And when the employee returns to work, that's going to be part of what you handle as part of the regular leave process. And of course, refrain from discrimination or retaliation. The Connecticut Paid Leave Authority has no official responsibilities connecting with FMLA. Like we're just not part of FMLA at all. However, as I mentioned before, it's really hard to talk about CTPL without talking about FMLA. So we've been doing a lot of training, and we're partnering with DOL to create toolkits and guides and other information to help employers. Connecticut Department of Labor is the agency that's responsible for enforcing Connecticut FMLA. So they're in the process of updating their regulations relating to FMLA, providing guidance, and they also investigate complaints regarding denial of FMLA or discrimination. So I see someone's raised their hand, but there's no way for me to let you speak, so throw it into the Q&A. Talking about FMLA, the employee has to notify the employer that they need time off from work for a qualifying reason. They don't have to use the term FMLA. Many of them won't, but they will say, I need knee replacement, or my dad needs hip surgery. I need time off. 30 days in advance if it's foreseeable, as soon as practical if it's not. The employer, most likely HR, has to determine if the worker is eligible for CT-FMLA or any other leave entitlements like federal FMLA or the other laws, which I'll talk about in a moment. And they have to tell the worker if there's anything that they need to do. Do you require your workers to provide med certs? I hope you do. You should. Make them do that. Under Connecticut FMLA and federal FMLA, you have 5 business days to tell the employee if they're eligible for those laws and to provide something called a notice of rights and responsibilities. This is not leave approval. This is just, okay, we're in the process. You employee have to do this. We, the employer, have to do that. The federal DOL has a sample notice of rights and responsibilities form available on the dol.gov website. Connecticut DOL is developing a sample form that employers can use as well that encompasses the Connecticut FMLA. So that's something to be on the lookout for in the next month or so. You've told the worker, hey, we need a med cert, we need those military records, we need something. They have 15 calendar days to get that documentation back to you. But if they tell you that the doctor just left for a vacation, or I'm still getting information from the foster care agency, they need to tell you that they need more time, and you should give them up to 15 more days. If they don't tell you that they need more time, you can deny them for failing to provide the documentation, but usually that denial is going to prompt them to get you the docs. So, but they do need to talk to you. Once you get that documentation, you have 5 business days to determine if the documentation is complete and sufficient. If it's not, you have to tell them what's wrong with it and give them time to cure. If it is, you have to tell them if it's approved or not. And when you do that, you have to tell them, are you going to need to use your PTO? Do you have to report in? Do you need a fitness for duty before you come to work? The employer has to communicate with you. Say it's a pregnancy situation, they want leave for childbirth and bonding. Well, they have to tell you when the baby's due, right? Then they also have to tell you when they go into labor. They don't just get to disappear. And you can decide how frequently you want them to call in. And then you track to make sure that they're not exceeding their 12 weeks. The employee it's a job protected leave, which means you have to return the worker to the job they had before they left. They have a right to return to the same job with the same terms and conditions. So if they were a second shift worker, you can't switch them over to third shift just because they took FMLA. Whoops, that's a typo here. That the employer cannot insist that the employee be 100% fit for duty or totally recovered. If the doctor says they are able to return to work, even though they may have some restrictions, you have to work with them to see if you can accommodate those restrictions. And that's what I mean by saying you must consider the ADA and CFIPA. So I need to fix that because it's an employer thing as well. ADA is the Americans with Disabilities Act. CFIPA is the Connecticut Fair Employment Practices Act. Both of those laws say you have to provide reasonable accommodations to an employee with a disability, which might mean equipment to help somebody lift something, or extra time to complete a project or something. So FMLA, I know you've been doing it already, and so I know you know some of these things. Managing your worker's absence can be tricky. You need to have and enforce your attendance and call-in policies. I'm telling you this from 20 years of experience. Having a good attendance policy and having a good call-in policy will simplify your life, because that way you know when your employees are out. Your supervisors know that they have to tell HR that an employee is out, not just let employees disappear and tell you like a month later that oh, Erin's been gone, we don't know where she is. And if there are consequences for violating your attendance policies, then your employees are going to want FMLA, because if there are no consequences, they're going to give you a hard time about having it be considered FMLA. And then they're going to take all sorts of time off, much longer than the 12 weeks that they're statutorily entitled to. So good policies and enforcing those policies is critical. Incomplete or insufficient med certs are a problem. The doctor has to complete, or the healthcare provider has to complete the med cert. Both federal DOL and Connecticut DOL have sample med certs for you. We're also going to be putting the med cert we are recommending on our website if you want to use that. But you want it to be complete. You don't want it to say absence is as needed, right? No, the doctor needs to say, based on my professional experience and my understanding of this employee's condition, I expect that they will have migraines twice a month, and each time they have a migraine, it'll last between 1 to 2 days. You want good, complete med certs. Intermittent leaves are notoriously difficult to manage because they're often unforeseen. So you need to make sure your employees understand that they have to call in, they have to report it as FMLA. If it's a foreseeable absence, there may be things you could do to restructure their work schedule. But sort of everybody recognizes that will take a fair amount of time. They require a lot more attention than like a simple, I'm having a baby, I'll be back in 6 weeks. Fluctuating work weeks can be tricky. You do have to calculate your average work week so you can figure out what their entitlements are. And then, as I mentioned, there's Connecticut FMLA, there's federal FMLA, there's ADA. You have to be aware of all of these things and manage that interaction. You may have to, if you're subject to both, you'll have to track it and say, oh, well, this is their Connecticut FMLA entitlement. This is their federal FMLA entitlement. When are they using Connecticut? When are they using FMLA? Sometimes it's going to be using both at the same time, but federal FMLA doesn't let you take leave for your grandfather, but Connecticut FMLA does. So you have to sort of manage both banks. And then you may have employees who say, I don't want this to be FMLA. I want to save my FMLA. Just let me use my sick leave for this. I'll save my FMLA for later. You don't want to do that. Under both Connecticut and federal law, it is the employer's right and responsibility to designate time off that qualifies under the FMLA statute as FMLA leave. You want to do this because it'll help you manage their leave. It'll help you make sure that they're not taking more time than they're entitled to. And it'll help you protect yourself from a claim that you denied an employee their entitlements or interfered with their rights. Employees can't waive their rights under FMLA, even though they say they want to. They could say, oh no, don't call it FMLA, and then they could come back and sue you for not calling it FMLA. So don't fall into that trap. If it qualifies and they're eligible, designate it. As I mentioned, there are other laws you have to think about. Federal FMLA, Connecticut FMLA, ADA, Connecticut Fair Employment Practices Act we've mentioned. There's also the Pregnancy Disability Act, which says you have to provide leave as a reasonable accommodation to individuals who are pregnant. And then there's workers' comp, which obviously provides income replacement and some measure of job protection for on-the-job injuries. There's really not many laws providing for income replacement other than CTPL, except for workers' comp. And it's important to know that if an employee is receiving workers' comp, they are barred from getting any money from CTPL. Similarly, if they're receiving unemployment compensation, they can't get any money from us. Or if they're getting Social Security disability, they can't get anything from us. Okay, I have no idea what time it is. It's 2:20. Let me just flag for you. Go to our website. We've got tons of stuff. We're actually launching tonight a new small business section and a claims section. So there's lots of information, but we've also got posters, we've got mailers, we've got fact sheets. So we've got a fair amount of information already, and there's going to be a lot more that's going to be available as of midnight tonight. And we're updating it almost on a weekly cadence right now. So information for you, for yourselves, for giving it to your employees. If you have questions that you can't answer, you can check out our frequently asked questions, which we're updating all the time. We have videos on our YouTube channel. And if you still need questions, you can contact us through the Contact Us button on ctpayleave.org. We do not have a call center because it's prohibitively expensive, frankly, to run a call center. But we do have an arrangement with United Way where the Contact Us questions go to a specially trained team, and they will respond to their questions in conjunction with the authority staff. And so, I don't know, we've received and answered tens of thousands of questions in the past year, and we're starting to see more questions related to claims. So that's another resource. All right, ctpleave.org. Like us, friend us. We'll be there for you. I'm going to stop sharing and look to see if anyone has any other questions. If you can put it in the Q&A, that will be helpful because we can keep it as a track. Now this one's done. I'm going to pause to see if anyone else wants to type in any questions. Or Gwen, if you have any questions, I think you've got the ability to speak, even though I can't give it to anybody else.
And I do have a question. So when we were talking about the affinity, the relationship, is it the employer that determines that relationship, whether it's acceptable or not, or does the state do that?
Great question. So the employer has to determine it for purposes of Connecticut FMLA, and the authority will determine it for purposes of the paid leave benefits.
Okay.
So, anyone have any other questions, either about paid leave side of things or the FMLA side of things?
Before we close out, Erin, may I ask another, well, can I make a general announcement to the team? If you could jump onto Teams when we close out this meeting for just about 5 or 10 minutes or so, just so we can just wrap up some other things from this meeting, if you wouldn't mind, that would be great. And then Erin, I would really like to thank you for your time and sharing all of this information. It's really a lot to absorb. So there's a lot to be done. So we'll see where we go from here.
So thank you again for having me. I would say in the next couple of months before everything starts taking effect, check out our website so you have you can use or adopt the messaging that we've created to sort of help convey information to your employees. Look at your attendance policies, look at your call-in policies. Make sure that they're compliant with the new rules that they talk about, the new extended relationships for Connecticut FMLA. But that's sort of the thing to kind of start getting people ready for. And then, as I said, both the Paid Leave Authority and the Connecticut DOL are working to create sort of more documentation, more guidance documents. So kind of keep that on the lookout for that.
Great. And you said you would be supplying the presentation deck, the slide deck?
So I can give you the PDF of the slide deck, and then we can also send you the recording.
Great, that would be helpful, I'm sure.
Great. I'll correct that worker employer on that one page. No matter how many times I look at these things, there's always something that slides through.
Sure.
All right. Well, thank you again for having me this afternoon.
Thank you. Thank you again for your time.
All right. Have a good afternoon, everyone. Bye-bye.
Great. Thank you.